So first of all, welcome everybody to this European Criminal Law Association event, which we've entitled UK Law Enforcement Access to Electronic Evidence Stored Overseas, the US and European Context Post-Brexit. So particularly thank you to IALS for hosting us again, as they have done for so many years. So just briefly as an introduction, when we were looking at events that we wanted to organise for this year, this was an event which cropped up. A number of people suggested. Particularly it is timely because the second protocol to the Budapest Convention is just about to be open to signatures. But we know that many in law enforcement and those dealing with cross-border crimes are recognising the proliferation of electronic communication devices, which, coupled with the problems of that data being stored on the cloud, has resulted in this exponential increase in the need for law enforcement agencies to access highly probative electronic evidence, which is held in a different jurisdiction, and having to rely on the mutual legal assistance process, which can be slow and bureaucratic. So as a result of that, we have seen reform efforts around the globe. And so this webinar is attempting to bring together experts from the US and from across the European Union to discuss the approaches of the UK, the US, the European Union and the Council of Europe, all to trying to address the challenges of ensuring swifter access to electronic evidence stored overseas. So I just have a few housekeeping matters. First of all, hopefully you will have noted when you come in that this event is being recorded, and that will include the question and answer session at the end of the presentations. There are a number of different ways in which you can participate. There is a chat function, and you are welcome to use the chat function as people are speaking. Sometimes it's easier to write your question or your comment as people are going. And everybody will be able to see that. There's also a specific Q&A function if you want to ask a question of the panel. This is a 2-hour session, and in the second hour will be open for discussions where the audience will be able to ask questions. Primarily that will be through the chat function, but it is possible for us to allow somebody to come in and be able to speak if you would rather do it that way as well. So I'm now going to hand over. We have 4 speakers today, as hopefully you might have seen on the posters that were advertising the event. Our first speaker today is Peter Swire. Peter is the Elizabeth and Tommy Holder Chair of Professor of Law and Ethics at the Georgia Institute of Technology, and is Research Director of the Cross-Border Data Forum, and he's also Senior Counsel with the US-based law firm Alston and Bird. Under President Clinton, Peter was Chief Counselor for Privacy in the US Office of Management and Budget, and he also served as one of 5 members of President Obama's Review Group on Intelligence and Communications Technology. In 2015, the International Association of Privacy Professionals awarded him the annual Privacy Leadership Award, and in 2018, Peter was named the Andrew Carnegie Fellow for his project on protecting human rights and national security in the new age of data nationalism. So we're very pleased that he has agreed to speak with us. The power of Zoom means that he's able to attend today from the US. So we'll hand over to you, Peter.
Gemma, thank you very much. And hello to everyone as I pull my screen share up, I hope. So Gemma, could you confirm it's visible so that?
Yes, I can confirm that is visible.
Hi, so I'm doing today, I'm a professor, as you heard, at Georgia Tech, but we're doing a lot of work in the Cross-Border Data Forum. And I don't know if it got posted, but we circulated to the organizers a list of publications the Cross-Border Data Forum has done on these topics. We've really been working hard on this for the last several years. As an overview, my thanks to Professor Gemma Davies and Northumbria and all the sponsors for hosting this event today. I'll briefly talk about my own background. I'll talk about the key role the Edward Snowden disclosures and the globalization of criminal evidence play in setting us up for where we are today. And then I'll do a tour pretty rapidly of a number of legal instruments and negotiations that are happening right now. One of those is the US Cloud Act. Another is the EU e-evidence proposal. There's a US-UK negotiated agreement connected to the Cloud Act. There's also big effects of the EU adequacy cases that the CJEU has been holding, and that there's been local recent enforcement actions on. And then in a very brief mention, there's multilateral initiatives such as at the OECD, the Budapest Convention that Professor Kennedy Mayo will speak about, and the United Nations Cybercrime Initiative. So all of this is going on about government access to data. As Gemma mentioned, I'm currently at Georgia Tech and a research director with the Cross-Border Data Forum. I also work with a law firm under University Rules for Consulting. I've been a law professor for what now seems like quite a long time. In the late 90s, I was working in the U.S. Office of Management and Budget during negotiation of the Safe Harbor Agreement between the EU and the U.S. I was the White House responsible official when negotiating that. And I've written many different topics, but including many things on law enforcement and national security. So in June of 2013, as everyone here will now remember, my students now, if they're undergraduates, don't necessarily remember this anymore. The Snowden publications began in the summer of 2013. And I think with these revelations, there was a huge spike in global concerns about how government intelligence agencies might access personal data. That August, President Obama asked me to serve as one of 5 people on a review committee to say, what should we do about the NSA in light of all these intelligence revelations? And from that, I had the chance to work with the White House. I'm the second person to the left of President Obama. I'm listening carefully. I'm not asleep in the picture. But we were there giving our recommendations, many of which actually turned out to be adopted. So from the review group, I became aware as a professor, as I left the review group, that there was a significant problem with MLATs, the Mutual Legal Assistance Treaties. That's the traditional mechanism going back decades to get evidence from one country to another country for criminal enforcement. And the simple answer that I think people who study it are very much in agreement on is that MLATs are too slow for the modern internet. There's so much data overseas, but an MLAT takes, and typically a US MLAT request to the US takes over a year. So that just seems really slow if you're doing a criminal investigation. And as part of that study, working with others, I created the Georgia Tech Cross-Border Request for Data project. And you can see our academic work and the conferences we hosted in the 2015 to 2018 period. So I think for purposes here, here's an idea to think about that we've written about, which is the globalization of criminal evidence. We're used to having globalization of so many other things, but maybe not as many people have focused on why there's a globalization when it comes to the evidence used in local criminal prosecutions. So one big change is that personal data so often is held in another country, is stored in another country, sometimes by an organization headquartered in that other country. If you go back decades, the MLAT request was very unusual, international drug smuggling or money laundering. But now international data held somewhere else is pervasively part of criminal enforcement. And one of the big reasons for that is the shift to cloud computing, where your storage for not just your email provider, but all the other organizations you work with may be stored in the cloud, oftentimes headquartered somewhere else or stored somewhere else. And there's many other kinds of internet and app activity on our phones, so that we've gone from being highly local. I lived for a year in Belgium and only called my family once in the whole year because phone calls were so expensive, to highly international. So today I'm in Atlanta, Georgia, and we're doing this conversation, and we've all been doing that during the pandemic. One of the results of this globalization of criminal evidence and issues that came from that is the US Cloud Act that was enacted by Congress in 2018. So the US Department of Justice had thought the law was clear, that the US can exercise its jurisdiction if PCC, if possession, custody, or control is in the United States. The idea is if you go to corporate headquarters, you can get the items that are controlled by corporate headquarters. In the well-known Microsoft case, Microsoft challenged that, said this should not be access to an email that was stored in Ireland, said that that's extraterritorial and the US shouldn't be able to get it. It got challenged up through the courts. And before the US Supreme Court ruled, and most observers, including myself, thinks the Department of Justice would have won, Congress went ahead and passed a statute. They passed a law that clarified what the law would be. The statute has two parts. The first part is the statute now clearly states this possession, custody, or control rule that the Department of Justice had used for decades. And now it said this is the law when it comes to stored communications for criminal purposes. And in the list of documents we provided you, there's a law review article we've written on what PCC means under US law. The second part, and this was related to research that we did, is this new idea of the executive agreement. You don't need a new treaty to update things. You can have an executive agreement. This will only apply under the Cloud Act if the other country, such as the UK or Australia, are the two that are currently been announced, if the other country has strong privacy and civil liberties protections. The United States is not going to want data to go automatically to, let's say, authoritarian countries. And if the other country has these good protections, you might think of it as adequacy, though the US law doesn't say that term, then the US blocking statute gets lifted. So under current law for many years, the US prohibits a service provider from providing the content of communications for law enforcement requests in other countries. And with the new executive agreement, the key goodie for the UK or other countries is then the UK could go directly to US service providers, and there's big famous service providers, and get the content of communication without having to go through MLAT. So that's a big carrot to have an executive agreement to help law enforcement, for instance, in the UK or the EU, to be able to get access to data held by US service providers. Meanwhile, the same problems are coming up with Europe, with the globalization of evidence. This applies to the EU member states once it's finalized. And DG Home led the study for why the EU e-evidence should be done. And the study found that over half of criminal cases within the EU rely on electronic evidence held in a different country. Once again, the norm now is that the data is held in another country or by a different service provider. And what is Europe going to do about that? So the solution, the basic idea for e-evidence, is to harmonize the EU rules so that a requesting state, I picked the example of Hungary, can go directly to some entity in the receiving state. I picked the example of Germany. And the benefit for this is that it greatly will streamline criminal evidence collection within the EU. So that's a good thing for law enforcement, because law enforcement otherwise simply might not get the evidence it needs to prosecute crimes that it needs to protect for public safety reasons. But there's also a risk. So how would you like it if you were German, for instance, if Hungary could collect evidence directly from German entities with no role for the German courts, right? That's a concern because there's Hungary rule of law concerns that the EU has officially recognized. And more generally, not just Hungary to Germany, but any member state to any member state, is it okay in general to lose judicial supervision in the receiving state? It's a concern that there's differences in these systems and the protection of rights might not be done as well if we streamline things in this way. So the e-evidence is currently in trilogue discussions, the Council, the Commission, and the Parliament. And from what I can tell, and I rely here for a lot of my information on our French colleague, Theodore Christakis, who's written about this, and also from meetings I had in Brussels earlier in the fall. But it appears the trilogue's at an impasse. The three parties don't seem to have a clear path to an answer. And many of the current proposals would give notice to whom? To the state of the service provider. And the service provider is supposed to make sure that Hungary and Germany have it sorted out correctly. Now, if we think about service providers in Europe holding the data, a great number of applications would go to Ireland, which has a relatively small staff to handle all these. And so I think if you're looking at it from a fundamental rights perspective, it's hard to imagine that the Irish authorities would be able to protect all of these different applications that are flooding through for all the different Irish headquartered places. So that's a concern about the current proposals in the trilogue. And so Professor Christakis and I, as a sort of helper to this, thinks it would be better if a revised proposal focused on what's been called the affected state. The affected state is the state where there's the biggest stake. So if Germany gets notice about a German person and their rights are maybe at risk, the affected state is Germany, and Germany should have some notice and some role to object if there's a Hungarian request. That's not currently in the EU trilogue discussions, but if there's really an impasse, it might be a chance to get to something that I believe would work better. Now, what about this US-UK agreement under the Cloud Act? Well, the UK, which very much wanted the agreement so they could get direct access to content, the UK enacted a law called the Crime Overseas Production Orders Act of 2019. And the law was able to check some boxes in the US requirements for an executive agreement. And the key that you get from this is that the UK, once it's in effect, will get direct access to US service providers for content, for law enforcement purposes, for serious crimes. Now, in January, back in 2020, the US government said, hey, we have an agreement with the UK. Here's the agreement, Congress. If you have any concerns, you have 6 months to vote to reject it. Congress took no action. That means from the US side, the legal authorities are complete. It could go into effect tomorrow. However, and interestingly enough, this agreement has not yet entered into effect. Today, the UK cannot go directly to US service providers. The US cannot go directly to UK service providers. And my understanding is that there's actually a connection between this US-UK law enforcement sharing and the new UK processes that have been announced by the UK government to seek to have adequacy findings. Now that Brexit's happened, the UK has to come to its own adequacy decisions if it wants to facilitate cross-border access. And in particular, for law enforcement access for that sector, does the UK believe that the US has adequate protections? In my view, and we could talk about why, I believe the US does to meet these standards, but you're not going to have this direct sharing across borders, it looks like, until there's some UK adequacy findings. The UK has not yet released any such findings under its new powers. Here's one slide which greatly simplifies things about the effect of EU decisions about what is adequate protection, notably in the United States. So after Snowden, as you know, there were great concerns in Europe about US intelligence access. And the GDPR, it's been documented, was blocked, was not going to get enacted, it looked like. After Snowden, within a few months, everything turned around. The parliament passed GDPR overwhelmingly. So we got that level of privacy protections that we're familiar with from GDPR. Along with this, the Court of Justice for the European Union had its famous 2015 case in Schrems 1, striking down the safe harbor with the United States. And its July 2020 case, Schrems 2, was specifically struck down Privacy Shield and put into doubt how the operation of standard contractual clauses would work for transfers to third countries. That applies to China and India as well, which have very problematic processes. But the US is one place where maybe standard contract clauses today aren't good enough. So, and again, has been widely covered. The United States and the European Union are heavily negotiating right now for a new Privacy Shield, a successor agreement that would get adequacy. And I do recommend, I think is interesting and different from what people have written. We had an article with my co-authors, Christakis and Ken Propp, formerly at the US State Department. We had an article come out last week in the European Law Blog, providing a bunch of analysis of how this may go. And we have a second article coming out shortly. Also, specifically about the Cloud Act type of things, the EU announced discussions, and now they've been authorized by the Council to have discussions with the United States about Cloud Act. And the Cloud Act is about law enforcement. It's about access for serious crimes. That's different from the intelligence collection that the Court of Justice focused on in Schrems. That had to do with disproportionate and lack of redress for intelligence collection. The Cloud Act has to do with how are we going to get law enforcement access, including the US maybe getting too much access under possession, custody, and control. However, these discussions, which are necessary to get to an agreement related to the Cloud Act, have been put on hold at least until e-evidence is enacted. Europe wants to have its own process clear before it says what the process might be with the United States, but e-evidence seems to be blocked right now also. This became newly important, the lack of a Cloud Act agreement became newly important with a German case in December in the state of Wiesbaden, sorry if I'm not pronouncing it correctly, which announced that it was going to block transfers to the United States because of Cloud Act, rather than because of intelligence things, that the US has too much access to its law enforcement extraterritorial reach in the court's decision. And I've written an article on that also. What that means is even if we get Privacy Shield, we're going to have continuing uncertainty about lawful transfers because of this law enforcement concern about this effective government collection. So now we have a case in a lower court subject to appeal, but a case saying Cloud Act all by itself is enough reason to block transfers to the United States. Along with these bilateral discussions I just listed, there's multilateral efforts to try to clarify global standards for law enforcement access to personal data. One is the Budapest Convention, and DeBray Kennedy Mayo will speak next about that. We've written in December in the Cross-Border Data Forum that the OECD has very extensive negotiations for guidelines for government collection from private actors. There seems to be negotiating problems there. Maybe they'd get resolved if Privacy Shield gets resolved. But that could be a place where democracies, rule of law democracies, could announce principles for what the democracies believe is the proper way to handle these government requests. And also this year, the United Nations is beginning discussions on its convention on cybercrime. This has been controversial. Russia and China were the two leading powers when it came to supporting having this cybercrime committee. It has very many problematic human rights provisions. The US, the UK, and the EU are engaging now in the United Nations process, and I believe would all agree that the current draft from Russia is seriously flawed when it comes to protecting fundamental rights. So in conclusion, just to sort of survey the landscape, we've had a reaction in the intelligence side to perhaps excessive collection. We have a reaction on the law enforcement side to legitimate problem that police face, that they can't get evidence that's held elsewhere. And we have this list of efforts to try to resolve and come to a new system for cross-border data access. There's a tremendous amount going on. We've been trying to participate in the debates and provide accurate information about them. And so I thank you for your attention. I'll turn it over to Professor Kennedy Mayo to be introduced by Gemma. Thank you.
Thank you, Peter. That's much appreciated. So our second speaker is Professor Deborah Kennedy Mayo, who is also a research faculty member at the Georgia Institute of Technology. She works as part of a small team who research, write, and teach on legal and policy issues concerning privacy and cybersecurity. She is also the co-author, along with Peter, of the 2020 edition of the US Private Sector Privacy Law and Practice for Information Privacy Professionals. And with her co-authors, she has written on cross-border issues focusing on the US, Europe, and India. Prior to her work at Georgia Tech, she was employed as both an Assistant Attorney General for the state of Georgia and an Assistant District Attorney. So Deborah, we hand over to you.
And thank you, Gemma, for the invitation and for that very nice introduction. So I am in the process of attempting to share my screen. We'll see how this goes. So as you just heard, I am a faculty member currently at Georgia Tech. And I want to just spend just a second on my background, which I have been a former prosecutor. So I look at things from certainly the prosecution side. I have also been an assistant attorney general for the state of Georgia. And one of my main clients there was actually the state agency in Georgia for public defenders. So I have also seen things from that side. I also want to note that my first academic article, which was in 2002, was on the Budapest Convention. And it looked at the balance that could have happened in the Budapest Convention between police power and privacy back in the early 2000s. Unfortunately, that didn't happen back then. So we are having this discussion today about the Budapest Convention and its second additional protocol. So the Council of Europe's Convention on Cybercrime that we know today as the Budapest Convention, there's been a group working on this second additional protocol. The focus has been on law enforcement access to data in today's world. And in May, as you've heard, that's going to open for signatures for parties to the convention. We've also been talking, and you just heard Peter talk about the general reasons that we need this second additional protocol. One, it's been 20 years since the Budapest Convention opened for signatures in 2001. And you've gotten to cloud computing, as Gemma mentioned. And also, Peter talked about the globalization of criminal evidence and that 2018 report that comes out of the European Convention, where they are seeing in their review that more than half of investigations involve cross-border requests to access electronic evidence. So now let's move on to the specifics of what we see in the second additional protocol. What are the specific reasons? Law enforcement needs access to subscriber information and domain name registration information, and law enforcement needs to have the data to act in an emergency situation. As to subscriber information, there has developed some uncertainty with getting access to subscriber information because there have been different standards applied across the world. In some countries, you have little to no protections for subscriber information, and in other countries, you have full protections. There has been some legal uncertainty after GDPR in particular about getting access to domain name registration information. So again, this is a focus for law enforcement at the beginning of an investigation, trying to figure out who we're talking about, Who is the subscriber? Who is the person that the domain name belongs to? In the emergency context, there has also been some legal uncertainty, particularly when you're looking at US-based service providers, about whether foreign law enforcement can access data in an emergency situation. And there have been several approaches taken, but that's been a concern. Another concern with emergency situations is just the definition of an emergency. And so the second additional protocol attempts to say, when you're really talking about an imminent threat to life or harm for an actual human person, then that's when we're going to let you act. Now, I will note here a bit about concerns for protection of personal data in the second additional protocol. The focus of the second additional protocol is access to data for law enforcement. The full slate of GDPR-like protections is not the focus. Now, in the second additional protocol, there is an acknowledgement that some countries want that level of protection for personal data. But there's also a recognition that not all countries want to require that level of protection. So if we take a step back and look at the Budapest Convention, when it's being negotiated back in the early 2000s, civil society groups at that time raised significant concerns that there are not specific protections for personal data in the Budapest Convention. That's what I'm writing on back in 2002. This is a missed opportunity to have addressed those concerns. And so we jump to the present. There is a deliberate effort in the second additional protocol to address these protections for personal data. That said, there are still numerous civil society groups, and this includes EFF and Human Rights Watch, who have cautioned that you may, with the second additional protocol, be weakening protections or even sidestepping due process rights altogether. And so we'll focus here on the protections of personal data, the way that you find this in the second additional protocol. I will say here that if you're reading the second additional protocol, what you're going to see is here's a list of protections, here's exception number 1, and here's exception number 2. Commenters that I have read suggest that those 2 exceptions are so broad that they actually can just take over the rule itself. And so the way I'm presenting it here is as 3 prongs, and you choose one. So the first one is really a list of required protections by the party under the protocol. And these are very GDPR-like. Limitations on the use of the data, safeguards for sensitive data, restrictions related to data retention, restrictions on automated uses, requirements for data security measures, limitations on onward transfers, and a requirement to have judicial and non-judicial remedies that relate to redress. But then on my slide, you'll see the big or. The 2 parties can enter into a formal agreement, or the 2 parties can mutually agree informally to how they're going to handle protections for personal data. And there has at least been suggestions that this informal agreement does not even have to be written. So we then get to a part of the second additional protocol that's really complex and really it is raising some real concerns. If the parties decide to use either the first part, which is that list, that first prong, or the second prong, which is the formal agreement, then the transfers are deemed to meet each party's requirements for international transfer, and no further authorization for the transfer can be required under that legal framework. So it's not surprising for most people that if the transfer occurs in accordance with that first prong, that laundry list, then it can be deemed to meet each party's requirements for international transfer. The more controversial instance has been under that second prong for the formal agreement. So if the party is able to meet the protections for personal data using one of the three options, then what do they get from the second additional protocol? They get direct disclosure from the service provider. So if we use the UK and the US as an example, the UK would be able to go directly to the US service provider and get subscriber information and domain name registration information. They would also be able to get expedited production so that the order from the requesting country, again, that example of the UK, could be seen basically as an order from a US court. And you could then, as a UK law enforcement officer, get subscriber information and traffic data in that expedited way. And then there's also that emergency provision. So it's an expedited disclosure using the 24/7 points of contact. And under the emergency provision, law enforcement would be able to get access to stored computer data, which is defined to include stored content, traffic data, and subscriber information. So now let's really look at this from the UK perspective. From the UK perspective, we can compare what you get under the UK-US executive agreement and what you would get under the second additional protocol. And I note here in the privacy protections in that first row that's there, that the UK-US agreement likely would meet the requirements of the formal agreement under the second additional protocol to deal with protections for personal data. So under the UK-US agreement, once it goes into place, UK law enforcement will be able to get direct disclosure from service providers of stored data, traffic data, subscriber data, and under appropriate circumstances, real-time interception. That's more than you're going to get under the second additional protocol. Again, you're going to get direct disclosure under the second additional protocol of subscriber information and domain name registration information, as well as the expedited production and the emergency disclosures. So at least once the UK-US agreement goes into place, you're going to get better access under the executive agreement than you will under the second additional protocol. Now we'll step back for a second and say, until such time as the UK-US executive agreement goes into place, certainly there is some reason for the UK to consider signing related to the US and accessing data from US-based service providers. But that would be in the future, the opening for signature in May, and then the US and the UK could then sign, at least theoretically, fairly quickly, and then these avenues would be available to the UK to access information held by US-based service providers. So there's some reason early on to really be thinking that from the UK perspective, there is an advantage related to the US in signing the second additional protocol. Because that's one of the questions for the UK is, do they want to sign the second additional protocol and what are the benefits? Probably for the UK, the better reason to consider signing has to do with other countries that are parties to the convention and are also looking at signing the second additional protocol. And the one that comes up first is EU member states. Now that's minus Ireland, because Ireland has, my understanding, has only signed, and minus Russia, who is classified as an observer. But you get most of the EU member states. You also, on the list of signatories to the Budapest Convention, get Australia, you get Canada, you get Israel, Japan, and of course the US. And so these countries are also looking at signing that second additional protocol. So if they do, then you could enter into those agreements with those countries. Now, For the EU member states, it's probably a little more complicated, and you might be looking at the UK having to agree to that list for EU member states to also be involved in that. That gets really complicated when you start pulling in the EU, but it's at least a path that's a possibility. And so we get to that European perspective. How is Europe going to be looking at the second additional protocol? And here, I'm not an EU attorney, and so I'm just going to raise a few concerns that I have heard that are out there. That three-prong approach to protection of personal data in the second additional protocol is concerning. That first approach, that is that laundry list, may be okay under EU law. It looks like it has a good possibility. The second and third approach are concerning. And in some ways, it's the second approach that is the most concerning because of that clause that says, if you use a formal agreement, then no further authorization for transfer shall be required under the legal framework. These privacy protections are data protections, are protections for personal data, are so concerning that the EDPB, the European Data Protection Board, came out with comments to the protocol that said, we're not certain that this is going to meet the requirements of EU law. So from that EU perspective, what benefit do you get from the second additional protocol? Well, at least theoretically, member state to member state, France to Germany. And again, I'm not an EU attorney. That could get very complicated. But another place to look are countries with adequacy decisions who are also signatories to the Budapest Convention and then may sign the protocol. And I put one caveat, at least for the time being, because there has been talk post-Schrems too, that countries with an adequacy decision, when they are up for their review, there then may be a look at their surveillance practices, and we don't know the outcome of that. But at least for right now, that would mean that countries that are both signatories and have an adequacy decision from the EU are Argentina, Canada, Israel, Japan, and the UK. So again, for the UK and EU member states, there might be some place to work here. I'm going to end with what you're not going to get out of the second additional protocol. Countries that have not signed the Budapest Convention and so are not likely to be in any way involved with the second additional protocol are China, India, and Russia. And you're touched on that proposed UN treaty on cybercrime that is out there right now that could address these issues, but we don't know right now if it's going to because negotiations are underway. And China, India, and Russia are involved with the UN proposed treaty. So thank you again for the time to talk.
Thank you, Debre. We will now move on to our third speaker, who is Andreas Gruber. Andreas works as a legal advisor in the internet and telecommunications sector with a focus on regulation of electronic communications services and data protection. He is currently head of legal at the Austrian ISP Association, ISPA, and is also chair of the Cybercrime and Cyber Security Committee at EuroSPA, whose key dossiers include the EU e-evidence regulations and the second additional protocol to the Budapest Convention. In addition, Andreas is also a member of the UN expert group on the development of a data disclosure framework, and he has long-standing experience in the cooperation between service providers and law enforcement agencies, including cross-border access to electronic evidence. So I'll hand over to Andreas.
Thank you very much for this kind introduction. I will also just share my slides with you. I hope everybody can hear me well and also see my slides.
Yes, we can. All good.
Perfect. Great. So first of all, thank you very much for the kind invitation to today's panel discussion. I'm very happy to be here. And I will try to now in the next 15 minutes or so to give you the ISP's perspective on the topic of cross-border access to e-evidence, with a particular focus on the second additional protocol to the Budapest Convention. And what I will try to do as well is to focus both on the situation of a small ISP, as well as a large company that offers its services all around the world and has, of course, completely different resources available than a small service provider. And so maybe to start with, I think, the first slide, it is nothing probably that I have to explain here in a lot of detail. It's basically the background of why we are having this discussion today. This is the basic outline of a mutual legal assistance treaty procedure, how it works currently. So how a law enforcement agency in one state would get access to data held by an SP on foreign territory. And without going into too much detail here, what is the big advantage from an ISP's perspective, especially from a smaller company, is that it works the same way as disclosing user data in mere domestic cases. So the SP basically receives an order from its local authority, from the local competent authority, and then discloses user data in accordance with the local criminal and data protection law, and has the legal certainty that when it does, it does not breach any of its local law requirements. In addition to that, and we've already heard about it also today briefly, there is what is known as voluntary disclosure of data, especially voluntary disclosure of non-content data, which is, however, as far as I know, a particularity under US law. I'm not familiar with actually any other jurisdiction that would explicitly or implicitly allow it, but to my understanding, and I'm very much aware that I'm risking here to say something wrong about US law with two US experts here on the same panel, but to my understanding, this is actually provided by Section 2702 C6 of the Stored Communications Act, that basically allows a US service provider to disclose non-content data to a foreign governmental entity, whereas, for example, it would not be allowed to voluntarily disclose non-content data to a US governmental entity, but only under certain limitations that are then further provided under the Stored Communications Act. Nevertheless, again, this is a particularity of US law, and me coming specifically from European-based ISP associations, from the Austrian ISP Association, but also from EuroISPA, which is the Pan-European ISP Association. Under European law, it is currently not possible to respond to any such voluntary or such a request by a foreign law enforcement authority. And the reason for that is quite simple. It's basically European data protection law that actually does not allow it. Because in order to be able to respond to a foreign production order, basically two points would have to be, two conditions would have to be fulfilled. On the one hand, there would have to be a legal ground actually for processing, for disclosing this data. This is required by Article 6 of the GDPR, and already here without any legal basis under the member state's law where the ISP is based, or without a provision in union law, there is already a lack of such a legal ground actually for processing. And in addition, where data is then disclosed actually to a law enforcement authority in a third country, also the conditions in Chapter 5 of the GDPR, which regulates the conditions for transferring of personal data to a recipient in a third country, they have to be complied with. And there is a quite clear provision actually in Chapter 5, which is Article 48, saying that a company may only transfer personal data to a third country pursuant to a judicial or administrative order of this country when this is based on an international agreement, such as a mutual legal assistance treaty, or, and that brings me back to the topic of today's discussion, the second additional protocol to the Budapest Convention. But without such a treaty in place, just to sum this up as an introduction, currently if an ISP under European law would respond voluntarily to a foreign production order, it would most likely risk a significant fine under EU data protection law. And so that's why it's interesting to now look at what the second additional protocol would provide. Here, especially Article 7 of the second additional protocol would provide. As we've already briefly heard before, basically it requires state parties to allow a service provider on its territory to respond to a production order in relation to subscriber information that has been issued by any competent authority in the other state, so that the other state has there quite a wide margin of which authorities it declares competent under national law to issue such orders. And then the ISP should be able to directly transfer the subscriber information to the requesting law enforcement authority. What is very interesting in this context is that it does not specifically require actually that the ISP would be obliged to be obliged based on this foreign production order. So also a system of voluntary disclosure to some extent would probably nevertheless be possible, but the ISP would have to be allowed or permitted by local laws to actually respond to a foreign order. And so what that does is it solves to some extent the problem that I've pointed out before, as it would provide the necessary legal basis for the ISP to process the data, insofar as it is, of course, then implemented the signature protocol by the state parties. But the second condition, when it comes to disclosing the user data to a foreign law enforcement authority in a third country, compliance with Chapter 5 of GDPR, and also that has already been mentioned briefly before, remains unclear. There are, of course, already, as we've seen, a list of data protection safeguards included in the protocol itself, but we've also seen that the European Data Protection Board, for example, in the consultation has actually provided a lot of additional safeguards that it would see as necessary to be included in the protocol in order to ensure that data that is disclosed based on the treaty still underlies the same high level of protection after it actually is not anymore controlled by then a recipient in a third country, such as a law enforcement authority. And so, as it remains unclear whether or not the second edition protocol, in fact, can provide here a solution actually for being compliant with Chapter 5 of the GDPR, what will play a big role in my perspective is also the national implementation of the signature protocol and actually the use of the optional safeguards that are to some extent already provided in the second additional protocol, and that some of them are also of high importance from the perspective of ISPs. And I want to address now in the remaining time that I have some of these additional safeguards that we would consider necessary in the course of the national implementation of the second additional protocol to the Budapest Convention. And the first pair here of safeguards that I'd like to address are provided in Article 7 itself, and that is that the state party where the ISP is based may require that any production order that an ISP on its territory receives has to undergo first independent supervision, or has been issued under independent supervision in the requesting, in the ordering states, such as, for example, by a judicial authority, most likely, or by any other independent administrative body. And secondly, there is also the safeguard that it may require that in any case, the competent authority on the territory of the ISP must be notified about any order or consulted by the ISP when it receives a production order for subscriber information. And both of these safeguards we see highly important as service providers. And it brings me to the first set here of concerns or of recommendations that we would have for the national implementation of the second edition protocol, because without an obligatory notification of national authorities, the service providers themselves would be the ones who then independently would have to assess whether a production order for subscriber information in fact is lawful, and whether actually the authenticity has to assess also the authenticity of such an order. And this in many cases will actually not be possible, in particularly for, again, smaller ISPs. So that's why we highly encourage actually to implement the obligatory notification of national authorities when implementing the second additional protocol. And secondly, if a production order for subscriber information is issued without any independent supervision, just pointed out before, the service provider might have to disclose this user data to third countries under a lower threshold and a lower standard than if disclosed on a national basis where such independent supervision might be required. And also, of course, this will create in practice, and just talking here from a more practical perspective, of course, some sort of also confusion on the side of the service provider when it has to disclose actually the user data under different thresholds to a national authority and to a foreign law enforcement authority. And for that reason, we are also actually very happy that the EU Commission actually encourages EU member states to implement, to make use of both of these options when implementing the second additional protocol. And so we hope that also the member states will actually follow these recommendations. Another very important aspect in this regard that should still be considered in the national implementation is the broad definition of subscriber information in the second additional protocol. So the second additional protocol does to us, quite surprisingly, has actually widened the definition of subscriber information compared to the actual use of this term in the Budapest Convention itself. So if you look at the explanatory report to the Budapest Convention, IP addresses are actually named as a specific example for traffic data. However, now in the explanatory report to the Budapest Convention, the state parties mention IP address as an example for subscriber information that should be under the scope here of Article 7. And these IP addresses, in particular login IP addresses, for example, the disclosure of such data can also reveal very sensitive details of one's private life, and for that reason underlie a higher threshold of protection and are considered, for example, also traffic data in several member states, and therefore also by the service providers who have their headquarter in these member states. And so if now, again, under this broad definition of subscriber information, the same data has to be disclosed as subscriber information, there is a clear risk, again, that it has to be disclosed under a lower threshold to third countries compared to disclosure on a merely domestic level. And that's why we actually would also encourage here member states to, for those who actually have this differentiation in their laws, to make also use of the option that is provided in the second additional protocol that would allow to exclude actually IP addresses and access numbers from this provision and include them under Article 8, which is the expedited AMLET procedure that is also provided by the new second additional protocol. Here, however, we see also that the Commission actually does quite the opposite. It encourages member states not to make use of this exclusion, which we see very critical. And actually, we see ourselves supported, on the other hand, by the European Data Protection Supervisor, who actually here also disagrees with the Commission and actually encourages member states, as we do, to make use of this option. A second or another set here of concerns that I still would like to address concerns more the security aspect, actually, of the protocol or of how you handle the data. On the one hand, we see problems with the verification of the authenticity of an order. So when you receive as a service provider an order on a pure domestic level, again, it's usually quite easy to determine whether or not this actually comes from a law enforcement authority or not, or it's quite easy to actually reassure yourself about that. However, if now in the future you probably receive requests or orders from potentially 50 or more states, this gets much more difficult. And so we disagree here with what is said in the explanatory report, where it says that actually the use of an official email address should already be regarded as sufficient, because we all know how easy it is to manipulate an email address. And so we very much encourage here also law enforcement authorities to add some extra information, information actually that would allow the service provider here to ensure the authenticity of an order. And last point that I'd like to mention is the lack of safeguards for security in the transmission of the data. So service providers usually underlie a very strict regime when it comes to cybersecurity, ensuring the confidentiality of its user data. And therefore, these efforts might be undermined where a service provider then has to disclose actually potentially highly sensitive information without the appropriate secure channels to a recipient in another country. So unfortunately, we have made aware of this fact in during the consultation process, unfortunately, no requirement to use secure channels for data transmission has been in the end included in the protocol. So that means potentially now a service provider could receive a production order via email or even via a fax message. Yes, unfortunately, some SPs still receive also fax messages. And I think we can all agree that neither of these technologies are a secure technology, an up-to-date security technology in the year 2022. And so what we would encourage here again, and I know this is a big step and that it probably would take several years to establish, but would be the implementation of a unified data exchange system. It is something that in the course of the e-evidence regulation, actually in the EU, has been discussed at the moment, to what extent that would be possible. But this, especially considering that, the world gets connected more and more over the years, and the need for getting access to data held by SPs in foreign territory will only increase. Such a unified exchange system, the need for such a unified exchange system will only increase in the future. And so lastly, what I would like to show you here, and just briefly a few minutes on that, because I think I'm already quite at the end of my time here. This is a graphic which basically explains the so-called Durchlaufstelle, as we call it in Austria. So the Austrian solution actually for exchange of data between ISPs and law enforcement authorities, and also a secure platform for exchanging data. And it's a blind mailbox system, to call it like this, where a law enforcement authority encrypts its request, sends it to this mailbox. So the mailbox is basically, it's a system that is administered by the Ministry of Interior. It's a platform that is administered by the Ministry of Interior, but the Ministry of Interior does not have any, cannot actually look into the requests. So that's why it's a blind mailbox. And so the law enforcement agencies send the request to this mailbox. The ISP receives a notification that there is a request coming. It then uploads the data, again encrypted, to this mailbox, and the law enforcement agency retrieves the data from this mailbox. It's quite a simplification of the whole system, but it's basically how it works. And the additional benefit is this mailbox then also provides statistics actually on the amount of requests and orders, and based on which legal obligation actually have been sent by law enforcement agencies, for example, in the past year, which gives quite a good insight also on for which, for example, crimes the most data is being asked for, or so on. So I know this is much easier to implement such a system on a national level, but again, on an EU level, it is being discussed right now, and we are quite sure that it will not work in the long run also without such a secure platform for exchanging of data, also on an international level, such as in the course of the second additional protocol to the Budapest Convention. Yeah, that's all what I wanted to mention here. If there are any questions, I'm happy to answer them. And otherwise, I'm of course looking forward also to the remaining panel discussion. Thank you very much.
Thank you, Andreas. Finally, we move on to Chloe Bethelemy, who leads EDRI's policy work on law enforcement and data protection issues, including cross-border access to data at EU and Council of Europe levels, Europol, EU police and migration databases, as well as information exchange. Chloe also has expertise relating to online freedom of expression and content moderation in the context of the terrorist content online regulation. And before joining EDRI, she advocated for youth rights at the European level. And she recently co-authored a compendium of scenarios illustrating the gaps in fundamental rights protections in the EU e-evidence proposals.
Thank you so much, Gemma. I hope everybody can see the presentation.
Yes, we can see that. That's great.
Thank you so much. Thank you so much for the invitation. I'm very glad to be taking part in this conversation. I was tasked tonight to actually tell you a little bit more about what is going on at EU level and a little bit the tricks that is happening with the e-evidence proposal that have been taking some time in the EU legislative process since it's been 4 years since the Commission released its proposal for this instrument. It's quite an important piece of legislation to look at, especially in the context of this conversation for which we were invited tonight, because the EU, well, is quite an important partner, but also this legislation is supposed to be the basis for future bilateral agreement with third countries like the US and the UK. As mentioned by Peter, the EU was reluctant to continue or slow down probably the negotiation with the US because the course of the negotiation on its own internal instrument didn't go as swift as it was expecting, with quite some diverging views between the European Parliament and the Council of Member States. So this is really something that the Commission is looking forward to achieve an internal position. It actually mentions it in its proposal for a council decision on the ratification of the Budapest second additional protocol. It says that it makes some recommendations for member states to ratify the protocol with a certain set of reservation or declarations to ensure that the compatibility of the protocol with the e-evidence legislative proposal. So the result of the negotiation on the e-evidence package will likely influence how the EU will later interact with the US and the UK. So as Peter already mentioned a little bit about the EU proposals, it comes from a frustration about the current situation with voluntary cooperation, especially with US private companies, notably Microsoft. But not only, obviously, but also an influence from the US and the adoption of the Cloud Act that enables the US to conclude bilateral agreement with third party, enabling this kind of data transmission across borders. And that was actually there was a big appetite on the side of the Europeans to cooperate with the US. Sorry, I had a slight difficulty with my presentation. The proposal came out in 2018, as I said, and it was shortly proposed after the adoption of the US Cloud Act. Basically, the kind of features of this legislative proposal is to enable what the Commission has coined as a direct cooperation with private companies, internet service providers, most specifically. This is not to be fooling anyone. This is not about cooperation. This is not about any kind of voluntary exchange and collaboration. This is a legal framework which includes also high sanctions in case of non-compliance from the companies themselves. We have been, as EDRI, so civil society in general, very critical of this proposal. First, because we consider that it bypasses existing traditional channel of cooperation, of judicial cooperation. It is taking out of those channels of cooperation several basic human rights safeguards, and it is shifting the burden to service provider to actually check out whether an order, a request for data is legal or not. So it's really problematic because private companies, private entities do not have the same human rights obligation that states do. And so it has major implications for human rights and fundamental rights freedoms online, including due process and defense rights. The approach is also to encompass all kinds of data, not just limited to subscriber information or certain type of traffic data. It also includes more types of traffic data and content data as well. The scope is quite large with some extraterritorial effect to a certain extent. We could call it like this. It encompasses service provider established in one EU member states or more, or that it offers services in the EU without an establishment in one of its member states. More generally, we're really concerned that this regulation, if passed in the spirit of the Commission's proposal, but also in the Council general approach, would be putting companies at the same level of a court or a state, because we had this bypassing of the other judicial authority in the requested state. And that would be really problematic if a company complies with an order that is abusive or invalid without having the requested state not being aware of, and even more problematic if there is no notification to the affected person that is foreseen in this framework. That would render the possibility to exercise one's fair trials right and defense right quite hard, actually. I wanted to also mention a little bit the context. We kind of tend as stakeholders in this debate to solely focus on this instrument and see it in isolation. And this is really something to remind ourselves that this instrument is just another tool in law enforcement authorities' collection of ways and possibilities to collect data and to share data among each other. So there is a certain amount of new legislation that are passed and were passed in the past years at EU level, but also at member states level, that increases the possibilities for law enforcement agencies to surveil people, to collect data more easily, and there are way more abilities and capacities to actually do that, thanks to the increasing use of online services. That led to for certain member states to disturbing levels of surveillance run by governments or run by their law enforcement agencies, and not only to certain scandals. One of the worst example being the Pegasus scandals. You might think it's not necessarily directly related to e-evidence, but to me, it very much is. E-evidence is just another tool if it doesn't come with the right safeguards and boundaries to continue surveil and repress human rights defenders, journalists, political dissidents, but also activists by way of collecting data on them. So this instrument will likely either could be abused to target the data of the categories of person I just mentioned, but also likely also be doing some kind of wide collection of data, among which certain data should be landing in the hands of law enforcement. Moving on to a bit more specific to the problems we see specifically with this instrument, it kind of ignores EU judicial cooperation principle. As I said, it bypasses certain safeguards that we've seen embedded for many years in the current instruments that we have for exchange of data, judicial cooperation, such as the principles of nebis in idem, the principle of double criminality, but there are other obviously important principles that I'm not mentioning because I want to save time. It could also give rise to potential conflicts of laws, which can have grave consequences for the persons affected. There are 27 different criminal laws in the EU, and an even higher number of constitutional judicial protections that differ from one country to another. And so, for example, that was illustrated when, for example, Belgium refused a couple of years ago to execute a European arrest warrant coming from Spain, and refused to extradite a Spanish rapper. At the time, Belgium considered that his lyrics, which Spain qualified as glorifying terror, were actually protected by freedom of speech and artistic freedoms protections. And so this is where you can see in this specific example on the European arrest warrant that an instrument like e-evidence could be problematic when faced with those conflicting criminal laws. Related to that, you cannot detect and stop politically motivated prosecution. You put all the power to decide whether an order is proportionate, necessary, in the hands of one member state, so the issuing member states. And so you entrust this authority to do the job. Unfortunately, we are at at a time where in the EU we have member states who have been over the years weakening their independent judicial systems, and that can no longer for a certain extent be trusted in their judgment to be completely independent from the government. And so this will be difficult to prevent this instrument from being abused by those governments or any kind of governments in the member states that wants to illegally prosecute people. You can also not protect individuals with certain immunities and legal privileges. Not all member states know that they are requesting data from maybe a doctor or maybe a journalist, someone that actually has legal privileges under the constitution of another member state. Those immunities, they exist for a good reason. They are here to protect important relations. They are here to protect important communications in a democracy, such as communication between a defense lawyers and their clients, doctors and their patient, journalists and the sources, etc. Lastly, you limit access to effective remedies, which is a fundamental procedural right, and thus you limit the rights to a fair trial. And clearly, this instrument is tipping the balance in favor of the prosecution side, notably by limiting the requirement to notify the person whose data is sought. And so, the longer you wait of notifying this person, the harder it gets to actually prepare his or her defense. Now, the biggest issue we see now is that none of the proposals on the table in the EU negotiation completely guarantee a sufficient level of safeguards for us. And more specifically on the issue of this direct cooperation, there is a lack of systematic and meaningful involvement of the member state of execution, so the executing member states, as we call it. We see this as an important safeguard, and currently this is not enough, neither in the Council proposal, which the Council General approach, that was adopted in December 2018. They require to a certain extent to notify the executing state, but this has very substantial limitation. It's just a consultation. Basically, it's like if the executing state decides that the order is actually illegal, might be unlawful. This is just an opinion. The issuing state can very much ignore it. Then it's limited to orders seeking content data. But that is absolutely problematic because traffic data, as ruled by the Court of Justice, can be as sensitive, if not more, than content data, or at least it can reveal very intimate information on a person's life. And then the reason for refusing to execute an order if the executing state wants to refuse an order from being executed, it's very limited, limited grounds of refusal. So if an order breaches the Charter of Fundamental Rights, for example, manifestly or obviously, the executing state cannot veto it, actually. In the Parliament, there is a better procedure that was built in by the MEPs in charge. So really thanks to an effort, I think, of a coalition of civil society organization, media organization, journalists, doctors, and also internet service provider, I think we managed to have good improvement in the Parliament's position. But those biggest improvements are only for traffic and content data, and there's some loopholes on the side of subscriber information, but I'll come back to that very shortly. What we recommend instead, obviously, is notification to the affected state. Peter mentioned it, why it's important. We also agree that it's actually very important to have this, especially when it is relevant when it's different from the issuing member states. So if Germany is looking for the data of a Hungarian suspect, for example, it's better that Hungary is involved in this. So involving the country of residence makes a lot of sense because their authority know about particular protections of a lawyer, a doctor, a journalist, etc. But we also, I kind of want to have an explicit agreement of the executing state, so a notification to the executing state. And that before the data transfer happens. So that means with suspensive effect. We need this agreement first before the data is sent. Yes, the executing state, because first we want to be sure that service providers are not faced with conflicts of laws. Again, they want to comply with their domestic law in the member state of where they are established. And this is better that their own authority give them a green light before they can transfer any sensitive data to a foreign state. So it's basically ensuring legal certainty for them, but it's also about the protection of people's rights. If an Hungarian independent journalist wants to protect their data by taking advantage of the single market, the digital single market, and use a German service provider, for example, but they are then targeted by the Hungarian government, it is problematic that there is no notification to the executing state, because in this case, no one will help them against likely illegal surveillance. What it means more financial resources for the judiciary. Member states should take on that. They should fill the gap. Yes, it is costly. Yes, we want to have access to data fast, but that means that you need to put the resources for that. I don't think it's appropriate in the EU that we sacrifice judicial protection and data protection for cheap and fast data access. I'm making here a parallel to the international agreement. We really do think that making MLATs more efficient and faster are possible. It's still possible. We don't see the counter argument to that. And that should be a priority. Lastly, the notification should apply for all type of data, not just the most sensitive categories of data like content and traffic, but also subscriber data. We think that will actually facilitate criminal investigation, because the identification of a potential suspect is key, as Deborah said. Yet, if the identity of one person is revealed to investigative authorities, but we find out later that in the process, the way the data was collected was unlawful, or that data actually benefited from special protection, shouldn't be used, basically, then the whole investigation may well collapse in courts. Lastly, we would recommend, obviously, to have a by default notification to the affected person, but that I mentioned it already. Basically following the Parliament's position. What will the EU position likely be? So that's kind of the last slide I have. It's hard to say, as Peter mentioned. It's like it didn't really move since a year now, since we entered into trilogues between the Council and the Parliament. There has been some package deal proposal made by both sides in the negotiations. None of them have succeeded so far. What will likely be, how they will kind of find a compromise between the two diverging positions is basically, it's just, all of this slide is basically assumption now, but probably no notification for subscriber information, and also a part of traffic data, so IP addresses mainly, and other type of identifiers thought for the purpose of identifying the suspect or the person they are looking for, that will be dropped. This is, I think, something the Parliament is willing to compromise on. The grounds for refusal after notification, in cases where notification is required, they will be more limited. There will be a more limited list than what we have in the EIO directive, so the European Investigative directive, which is quite problematic, because this list was already, we could say things about it. I'm not going to develop, but I think this is the absolute minimum what the EIO contains. Then there is this idea of residency criterion, for which the Council is not willing to move or to compromise on for now. That is the kind of the idea that when you are required to do a notification, if you have strong belief that the person whose data you're looking for resides in your own territory, then you don't need to notify anyone. You don't need to notify the executing state. You just issue the order to the service provider abroad. But we are going back to square one, for which we had strong criticism. And also, we don't think the issuing state has a very neutral position in evaluating or guessing if the person resides in its territory. It has all the interest to decide that this person resides in its territory, so it avoids the red tape of going through the notification process. Lastly, the possibility to not inform the affected person. The Council is pushing quite hard on having the possibility not to inform the person when it might interfere with the investigation, ongoing investigation. To me, it's like, when is it not the case that when you're seeking data, there is a risk that the person knows about it and start preparing his or her defense? Of course, this is something you could expect. So that might be used too much. And this is to be seen. This remains to be seen how this exception will be used in practice. I will stop there. I think I made my time.
Thank you, Chloe. So just before we move on to discussions, I just want to thank all four of our panel members for just really interesting presentations. We have certainly asked you to try to cover a lot in a really short period of time, and you've all managed to do that superbly. So we've covered US-UK relations, the Cloud Act, the second protocol, EU evidence. So we've really covered a lot of ground. Before we start working through some questions, I did say to our panelists that I would give an opportunity just to respond if there's anything that in some of the other presentations they might want to respond to, or anything that they've particularly noted or thought about. Don't worry, putting you on the spot, but is there anybody that wants to add any comments?
Maybe I'll say something briefly if I could, and I think Chloe's the last few comments really emphasize this. There are two such contrasting perspectives for people in these discussions. If you're in law enforcement and if you see your ability to prosecute half of your cases really get diminished, that seems like a huge hit to public order and public safety. And if you're on the fundamental rights side and you see hard-fought protections that are clearly established in European law being discarded, apparently, and this seems like an unthinkable thing from the fundamental rights side. And I think it's a great challenge to our institutions how to proceed when both sides have such an important part of truth that they're articulating. It's hard to even know how to discuss making compromises between letting criminals get away versus reporters' privileges. It's very hard to know how to have those discussions. And I think what I've seen across these discussions is that many people come to it firmly convinced of the importance of their perspective and having a lot of truth for the importance of the perspective. What's been harder to figure out is how to build things that seriously respect these different perspectives and are workable. That's what we've tried to do sometimes. There's people of good faith who are correct, who have the different perspective. And it's been very hard to know how to proceed, I think, is my observation.
Thank you. And Debray, you've got your hand up.
And I would certainly echo what Peter has just said. These are very difficult issues, and both sides certainly have something to bring to the table. And it's hard to figure out how to go forward. So on a practical side of some progress that is being made, that I want to highlight that dovetails on Andreas talking about the unified data exchange system, which I certainly think is of interest. One of the groups that I work with and Peter works with is the Internet and Jurisdiction Policy Network, that have done a great deal of work trying to get some interoperability into the requests that are being made, and really, again, along those same lines of that unified data exchange system. So I will put a link to some of the work that's been done. They have done some with the UN. And so I think it's really positive of looking for things that can be done that will help this system. And then the more complicated issues are the ones that Peter just raised.
Thank you. I think I meant to say actually at the just before there that we will send a link to the recording of this session, and we'll also include links to the things that Peter's referred to, and perhaps what you've just referred to there, Jabri. And I'm sure that would be very interesting to those who have signed up for today. So we've had there's been a couple of comments, I think at the end, which really are touching on what we've just discussing there. I think a lot of people's sort of natural reaction is to sort of to worry about the human rights implications. And one of the comments was about admissibility of evidence. So some of these are quite difficult, and obviously, but I suppose the whether we've thought through the extent to which these provisions will result in evidence which is admissible and isn't going to be routinely subject to challenge, whereas we've been through that process with MLATs, and MLATs, generally speaking, are used because the way in which we obtain that evidence ensures that evidence is admissible at trial. Does anybody have any comments about that, or would echo some of those concerns, or do you think that the framework which is being established adequately would adequately deal with issues of admissibility? It's a hard question.
I will say, with the second additional protocol, I think at least under the formal agreement that I discussed, there is an idea that you would be complying with the legal requirements in each of the parties, so the two parties that were entering into that formal agreement. So the hope there is that you would be complying with those systems enough that I think that you would be able to get that evidence into court. So I think that is the design. Now, whether or not, the details make that work is different. You could certainly challenge whether you comply with that. But I think that is the idea behind part of the formal agreement.
Thank you. So we had a question come in earlier on, which was partly answered, I think, to Bray, which was asking about the extent to which we can see different definitions of the different types of border, so content, subscriber, traffic, and how these are dealt with. I think we've had some comments on these, and I think also Andreas dealt with some of those within the second protocol. Is there anything anybody else would add to that, particularly in relation to the interoperability of these different sort of systems? So we've got EU, we've got the second protocol, we've got the US's approach in the Cloud Act. To what extent are there potentially going to be problems with different definitions of data types?
So one place that you do see some concerns has to do with IP addresses, static and dynamic, and different approaches. And certainly from the European perspective, it gets complicated on the level of protection that you're going to want to have, or that seems to be there even in some of the explanatory notes, that there's some almost tweaking that it looks like happened as some of that commentary was happening. And so that becomes really complicated, and it's much less so from a US perspective. So that just seems to be an example. And again, it's one of the reasons that I think that the concern about whether this is going to comply with EU law has cropped up, that as well as the domain name issue, because under GDPR, it seems to be, well, you can't just give over that information. And then second additional protocol says, well, that's one of the things that you can get. So those seem problematic. Again, I'm not an EU attorney, but those two concepts really seem to be problematic.
Just something from with US prosecutors. I've worked a little bit on the prosecution side, done privacy for a lot of years. The prosecutors in the United States would say something like the following in terms of the common sense, is that it's important in their view to get the subscriber information so that then they can create a set of evidence to be able to ask for harder to get court orders. So first you have to figure out who the person is, then you add in additional facts about why you think there's criminal behavior. And in the US system, eventually you can only get the content if there's probable cause, which is a relatively strict standard. And prosecutors in the US would say, we can't get to probable cause if we can't figure out who the person is. So let us know who the person is. We'll fill in a lot of other facts, and then a judge will decide if it's met the intermediate standard for traffic or if it's met the higher standard for probable cause. If you cut off subscriber data, the investigation just never gets started. So that's a concern from the prosecutor side. It is for sure that with enough IP address information and other traffic data, you can start to build up really big profiles of a person's life, and that's the privacy concern. But the prosecutors don't know how they're ever going to get a real court order for the most sensitive stuff unless they can first find out who the target is.
And I think that is one of the concerns, that actually the way in which things have developed, that actually traffic, you've mentioned it there, that traffic data, certain types of data can actually, when put together, build up quite an extensive picture of an individual without necessarily requiring access to content data. One of the questions that came in, and I think this was mainly directed at Andreas, but for anybody to come in on, was whether EU-level amendments to GDPR would be necessary to allow EU member states to implement the second additional protocol domestically.
So of course, there could, it would make life it would make the implementation much easier if you would just abolish GDPR or Chapter 5 of the GDPR. It makes easier, not that it would be the way forward, but of course, that would be a solution as well. Let's just get rid of the GDPR and then we have no problem with the second additional protocol. No, but to be serious, I do think that the safeguards included in what was referred to as the formal treaty could probably be considered sufficient in order to ensure an equivalent level of protection once the data has been transferred. However, it will, and that is something that has not been addressed yet, I think, it will also very much depend on the implementation actually of this provision nationally. And I think there it will then, that will be rather problematic maybe in some countries to what extent they can actually implement the safeguards that are actually provided in Article 14. And so to sum it up, I don't think that there are any changes necessary to the GDPR, but it will be rather necessary to actually then assess on a case-by-case basis whether to each and every country these safeguards are sufficiently implemented in order to ensure that Chapter 5 of the GDPR is being complied with. And so I think, and from that perspective, that brings me actually to one concern that I wanted to raise before. What we, of course, as service providers want to avoid is that this single assessment then relies on the service provider again. So this is something that we see now after Schrems 2 decision with data transfers from one entity to another entity, that actually the service provider or the data exporter actually has to assess whether the data importer can actually comply with the rules that actually it has agreed on in the standard contractual clauses. We would like to avoid something similarly when it comes to disclosing of data to law enforcement agencies, that then the service provider would have to assess independently each and every time whether the country it discloses the data to actually can comply with what it actually has said or what it has signed to in the second additional protocol. So I think that will be an important aspect. Also, the kind of some of the countries that are part of the second additional protocol in the Budapest Convention, they have also ratified Convention 108 of the Council of Europe. So for those countries, I think it's less problematic, but several other countries have not. And I think there it will have to be seen actually whether these safeguards in the treaty itself are actually sufficient.
One thing I've heard with respect to service providers is certain problems of conflict of laws that are becoming more acute here. So here's an example. Under Chapter 5 GDPR, there's an increasing amount of authority that says that it's not proper to send data stored in Europe to the United States such as under Cloud Act requests, because there hasn't been a clearly lawful basis for the transfer. On the other hand, you'd have a U.S. court order that says there's possession, custody, and control, so you must transfer the data. That's a classic conflict of law problem. You can't under European law, you must under U.S. law. There is a conflict of law provision in the Cloud Act, but it only applies once an executive agreement has been reached. And so that's leaving real life service providers today in a complex situation on conflicts of laws. It's one of the reasons that would support having an EU-US agreement related to law enforcement access, because under Article 48 GDPR, then you'd have a formal agreement, and that would say what can be sent and what can't be sent. But if we don't have that agreement, EU-US, this conflict of law problem is likely to be quite substantial.
Andreas and Debray, I didn't see who had their hand up first. Whoever wants to go next.
Go ahead, Andreas.
No, please go ahead. I think you were first.
I'm going to quickly attempt to share the screen again and see if this works. Because when I spoke on this slide, I think this creates a complication that a lot of people are not necessarily fully addressing right now, particularly in the EU. This is Article 14, Section 1D. It says if you are transferring that data based on that first prong, which is the list, or the second prong, which is a formal agreement, you can't do further assessments. That is deemed to be complying with the requirements for international transfer. And so I think that puts in place a real quirk in this. And I think that's why the EDPB, part of the reason they come out and say, we're not sure that this is going to be in compliance. And, you know, again, I'm not an EU lawyer, but I do think this creates a real quirk.
Yeah, I completely agree with you. And I also see the problem, maybe to first follow up on this. What if the Court of Justice then, after it has been, has done it also in the past, will declare this as non in accordance with the GDPR, whereas at the same time, the signatory parties have actually, in an international treaty, agreed that it is actually in accordance with EU law. That will create a very interesting situation. And again, talking here from the service provider's perspective, a lot of uncertainty whether or not you then actually are able or should actually be able to respond to foreign data requests. One thing that I actually, why I first raised my hand was Peter's remark on the EU-US agreement, the US cloud agreement, or potential EU-US cloud agreement. How I understand it, and maybe I'm wrong here, but in order actually to get into an executive and an agreement based on the Cloud Act, the EU would already have to actually abandon Article 48, or basically remove, actually, it's not abandon, but actually remove its, so it has to reciprocally actually allow also US entities to send orders to EU-based service providers. So for that reason, actually has to actually, remove this blocking statute that Article 48 is. So actually then the potential, but the possibility for a service provider to raise that there is a conflict of laws would not exist anymore, because actually in order to enter into such an agreement, you actually have to already to get rid of what potentially would hinder you to disclose this data. That is at least how I understood it so far, but maybe I'm wrong.
Well, we'd need to see what the agreement says. So the agreement would be something that would be negotiated by the EU and the United States. What if such a thing were to happen, it would be a formal agreement under Article 48 GDPR, as I understand it, that would provide a lawful basis for transfer. Now, part of the Cloud Act requirements is language about things like free flow of data, that the non-US government has to agree to certain kinds of open data flows. And that would be subject to negotiation, I think, in the discussions. It's not as if all limits on data flows have to disappear to meet the Cloud Act side. So I think the way I'd look at it is it's not an inevitable problem, the way you said it. It's rather a topic for negotiation, so that hopefully you'd get clear from that what defenses would continue against a U.S. order and what ones would now be considered to be valid under a U.S. order. That's how I think I would look at it. But the EU side, I'm sure, would based on my experience, would be very aware of such concerns and would negotiate hard before it was just handing out data that it thought wasn't appropriate to hand out.
And so in those negotiations, wouldn't you also get that from the US side, you could challenge, but that you would probably not be challenging based on, say, the Fourth Amendment to the US Constitution in the same way, because that's part of the reason that you would have this executive agreement. So both sides would be getting something and giving up something.
Mm-hmm.
Right? So you would negotiate and limit and decide what you still wanted to be able to challenge with.
Mm-hmm. No, I was having more in mind. The issue that Peter has referred to before, which is the conflict that now exists for an EU subsidiary, for example, of a US company that might have to disclose data based on the first part of the Cloud Act. In order to enter into an executive agreement, the EU would actually have to solve this issue as well in order to enter into the executive agreement that then would concern all other data. And that's what I meant. So basically here, this would play a role actually, and it would have to be first solved before you actually enter into the agreement. That's what I was referring to.
Chloe, did you want to come in?
Yeah, I just on this issue of the EU-US agreement and negotiations, we were asking actually the Commission, and this is also a question to others because actually how this interplay with the umbrella agreement, because this is also written, it's directly mentioned in the Commission's proposal for the ratification of the second additional protocol. And it says that the umbrella agreement should be completed with additional safeguards to enable the transfer not solely between authorities, but also between an authority and a service provider. And that was the first time I heard about the umbrella agreement in the context of this conversation. Although I missed some of the years before of debates before I joined this field. But to me, that was new that the EU-US, the EU-US agreement will be attached or somehow act as an annex, or I don't know how it would play out with the umbrella agreement. But that is an interesting point I wanted to raise, because for us, the umbrella agreement will also benefit from just being reopened and reassessed in light of the Schrems cases. This is likely our opinion that we're not sure it will satisfy or meet the level of requirement of the Court of Justice of the European Union, especially because of the lack of fundamental rights protection assessment that are regular, and the fact that the umbrella agreement doesn't discuss a US provision.
I think I can provide some clarity on that. I hope. Apologies if I have. So the umbrella agreement by its terms today, I understand, authorizes transfers from an EU law enforcement authority to a US law enforcement authority and vice versa. But it doesn't, by its terms today, authorize transfer from either side to or from a private entity. So to the extent the US law enforcement is going to be bound by the promises of the umbrella agreement to do proper data protection, they're bound, the US government's bound when it has direct interface with the European authorities, but not if there's a direct interface between the US government and data coming from a company. I think that's what you were referring to, that it didn't contemplate that kind of transfer between company and US law enforcement. And so the safeguards aren't promised when there's a transfer between the company and US law enforcement. That's one specific thing about the umbrella agreement. And then, if you reopen that part of the umbrella agreement and require some change, then I could imagine all sorts of different people wanting all sorts of different things that would change in terms of what the umbrella agreement says. And I've spent some time researching how the US law enforcement sector would look under an adequacy decision. I haven't published anything, but I've looked at it. And I say that there are more significant safeguards within US law enforcement, especially when it comes through the Department of Justice, than many people recognize. But that the US system, because it's a federalist system, is so complicated to assess whether this city police force is going to do something or not, and whether that are going to be questions from the privacy side about how thoroughly every kind of protection is done in practice. And because law enforcement is so decentralized in the United States, there may never be a way to lock down and show that every kind of transfer will always have each kind of safeguard. I've heard that there's 10,000 different jurisdictions in the United States with law enforcement prosecutorial authority. And, some of those are little towns with 100 people in them that don't have, as many safeguards in place. And so the complexity of that discussion will be great to the extent that almost all of it actually happens with respect to federal prosecution or a few major internationally prosecuting state. You can get safeguards for that. But I think there's going to be U.S. constitutional law questions that can't be solved if you insist that every local police department do things. I don't think the U.S. government under its constitution can tell those police departments to do those things. But you might say they just don't get access to the evidence. So there's some real complexity if everyone has to study up on umbrella agreement again. But the protections at the Department of Justice level, I think, actually look quite good when you go into them in detail.
I think that those discussions are linked, and I think, Peter, in your presentation, you did talk about this. So obviously we have a UK-US agreement, but it's not in force. That's because of the UK side. Exactly why is not clear. That's my understanding. We don't have any formal announcement, so we have to surmise why we think it's not coming to force. One of the things you're putting forward is, I think you're relating to the ADPB had concerns about the UK-US agreement when it was commenting on the UK getting a data adequacy decision after it left the European Union. There were negative comments about the agreement. Now, I suppose, so I think from that, what we're really saying is that unless the US EU can resolve these issues, it's actually going to be quite difficult for the UK and the US, despite the fact that the UK has left the European Union, to also be able to work through those issues if the UK is to maintain a data adequacy decision or not jeopardize its data adequacy with the EU. You're nodding, so I think
I don't know. Debray has her hand up. Did you want to say, or should I go ahead? Okay, so two observations. One is, my understanding is that the umbrella agreement applies to EU member states and does not currently apply to the UK. And so a great big set of safeguards with respect to data in law enforcement currently exists with respect to France and the rest of the EU, but not the UK. So you could imagine some effort to do something that looks more or less like the umbrella agreement being a way for the UK to get to the view that there's adequacy, or at least assess that there's adequacy. And without that umbrella agreement kind of protections, I think it's harder for the UK to say why the US would be adequate.
Debray?
And so I'm going to follow up with perhaps a different way to look at the umbrella agreement, EU-US, that may have gotten to the question that started this of why it might be being viewed as an appendix to the second additional protocol, or that these are related. The requirements of a formal agreement that are set out in the second additional protocol, it is possible that there are people who read that or are trying to read those requirements for that formal agreement to say that, in fact, the umbrella agreement does meet those requirements, which would then suggest, and I'm not saying that this is a correct interpretation or that these people actually are doing this, saying it's possible that they are saying that there is actually a formal agreement that's already in place between the US and the EU. So if a particular member state wanted to sign the second additional protocol, then they would already have in place a formal agreement. Now, whether that complies with EU law, all those are separate questions, but it is possible that's how the umbrella agreement is being looked at in relation to the second additional protocol. It's possible.
Thank you. So I think we had some comments that came in, and this links to, I think, Chloe's presentation, where Chloe's saying that effectively they would still argue that the MLAT process can be, if more money was ploughed into it, if there was more investment in MLAT, that MLAT could be improved. I'm just asking the other panelists whether you, sorry, Chloe, the extent to which other panelists either can see that argument, or whether you think that we have to move forward with finding a solution, a different solution for e-evidence.
I can say a little bit about that. So after the Snowden round of problems, the US amended a variety of its laws, including amendments to some of the MLAT procedures to make them easier to operate. One of the big things is it used to be an order would come into, or a request would come to the Department of Justice, then it would go out to California or something for the local office to try to issue an order. Now they can also issue the order in Washington, D.C., so they don't have to wait for some other office to do it. So that's like one example of a streamlining that I think has been useful. And there also was more funds put into it as part of the appropriations process, as part of the USA Freedom laws in 2015. So there's been efforts on the US side to improve it. I haven't heard anything like people saying who are part of the process that now it's all better. You know, that there's no one has said now it's working great. That they're saying a couple of the roadblocks are better than they were before. I'm not aware of current initiatives that know how to streamline it tremendously more than that.
I will just quickly say that in the comments to the second additional protocol, as it's going through its versions, civil society is certainly agreeing with Chloe's point that is what they would like to see. You know, at least I'm not saying everyone, but that's a general theme that you were getting. That improving the MLAT process is something that people would like to see in civil society.
Just before, Andrea, you're just jumping in, I just want to say that we are part of this civil society coalition in the context of the Budapest Convention, and we're working
I'm very much
collectively
aware.
with EFF.
I've read, and so it's you, and it's also other players around the world and individually that are chiming into that. And so if that didn't come across, that's exactly what I meant. Yes, they're
exactly.
Yes.
So what I would just actually like to, so first of all, I do support the idea that actually additional resources on a state level could contribute, of course, to a better functioning of the MLAT procedures. I think there is still some potential actually to get the MLAT system better running with the necessary resources and with some improvements in how the whole system works. And I think that is actually what Article 8 of the second additional protocol also tries to achieve to some extent. So what I would have liked also, and talking here both from personal perspective, from service provider perspective, is to do maybe a cascade approach and first try to improve the MLAT procedure by means such as an emergency MLAT procedure, by means of the Article 8 procedure, and see if that works, and then see what is still necessary, where do we still need maybe really direct cooperation for what instances, before jumping 2 steps actually before trying the first step. So that would have been, to me, my idea how could have approached this, and maybe would have avoided some of the problems that we're talking now about here.
On the US side, those reforms were 2015. So they've been trying for a bunch of years, and they've put in reforms that they could think of how to do. So we've been living with that and don't have a new round of proposals for how to improve it. On the US side, and because there's so many US service providers, the US is often seen as the bottleneck. So I'm not sure, I literally don't know I don't have a proposal right now of how to significantly change the US side of the process.
But Peter, do you know, in 2019, I think there was a report by the US Department of Justice that showed that the increase in budget and the streamlining you were talking about reduced the pending cases by 1/3. And I thought that was a quite incredible figure. And I haven't had the curiosity or didn't had the time to actually check for the next report of the next years, like in 2020. I'm wondering if this is because they were simply now with the Budapest Convention and so on, everybody had just so much energy to spend on those new instruments rather than actually focusing on the efficiency of MLATs. And I can not agree more with Andreas.
So I don't have current numbers. I was part of the creation of a number that's often cited. That was in our review group report. We reported that the average MLAT was on the order of 13 months. That was not a precise statistical analysis. We thought, after many interviews with people, that was roughly what people thought the answer was. And we thought having a number like that would at least give people a general sense of what the process is like. So if it's 13 months and you knock a third off of it, you're at 8 or 9 months. And that's pretty slow in the world of people who are trying to go after crime. The data might not exist 8 or 9 months later, oftentimes, to go after the criminal. And that's the sort of concern the law enforcement people would cite.
Maybe just one question, because you probably have much more insight in this than I do, but where is actually most of this time spent? Because it's not in the disclosing of the data by the service provider. That usually goes rather quickly. So the last step is usually rather fast. What happens in the 9 months?
So the examples, we did an article on France. So the article in France, it would go from the French magistrat or police request up to the central authority, over to the Department of Justice. Then it would have to, no? Yeah. And then the Department of Justice, if it has to make sure it's compliant, so it has to be in the proper form. A large number of MLAT requests, when they arrive at the Department of Justice, don't meet all the criteria for probable cause for content. And then there's often a back and forth between the requesting country and the Department of Justice, 2 or 3 rounds saying, no, you have to say this, or you need more evidence. Then once that happens, it goes to now most often the DC court, where then they have to apply to a federal judge to issue the warrant. That can take a while depending on what the backlog's like. Then for the first time, the federal warrant goes to the service provider, which has this request that arrives. They have a huge number of requests. They have to go through their processing. But then when it goes from the service provider back to the Department of Justice, there's a review to make sure that all U.S. constitutional protections are applied there. So there's a manual review, for instance, that is not evidence related to free speech offenses or other offenses that are not something the U.S. will share under the U.S. Constitution. And at that point, it leaves that manual review. It gets sent back to the French Central Authority. It gets down to the French prosecutor. There's a lot of steps there. We all know how busy we are just doing our jobs every day. And I don't think it's one step that means all of the delay, but it's a lot of steps. And so the average gets much higher because of those steps. There is an emergency procedure, and it's worked, including for the Paris bombings cases, but that can only be used exceptionally. And so I think it's the literal step-by-step of each, service provider going through their process. Then they have to find the evidence. Then they have to narrow the request to only that's what's responsive. There's a lot of different places where the time can accumulate based on the interviews we've done. I don't know if that's helpful, but that's what I've heard.
It is very helpful. I mean, the time that elapses on the service provider's side is the same with a direct request that is in an MLAT procedure. So I was just wondering, what is the additional time that actually elapses in the MLAT procedure? And so what I just now it's probably something that has been thought of, but for example, in order to avoid this going in between the requesting state and the US in this case, you could use certain templates already that actually would force the state to already provide exactly the information it might need, because I'm totally aware that the concept of probable cause is something very, with which most lawyers in the EU are unfamiliar with, but is also only actually, as far as I understand it, necessary for content data. So this would not be again for other sorts of data.
But non-content data,
right,
you can go directly.
So that probably would not
the blocking
exist.
statute only. The blocking statute, which is the biggest concern, only applies to content data. So that's where the fuss is, because that's probable cause.
Right.
Okay, thank you. So we are just coming to the end of our 2 hours. I think what we can see is, I think the UN provisions were briefly mentioned. So we've got this web of of different agreements stretching across continents, and the question, I suppose, the extent to which there's going to be interoperability between these different agreements, the extent to which there might be divergence or convergence, which might in fact create as much differences in different legal, it might not make things any better, I think, for ISPs, possibly, if we've got lots of different agreements in different regions of the world that have different standards and different approaches. So it's been really interesting to try and talk through some of those discussions from a UK, US and an EU perspective. So thank you to everybody for your time and for your really interesting presentations and discussions. So thank you.